last name. I'm so sorry.
Hi, Leslie Jahangiri.
Jahangiri, thank you. Miss Fidel, that's a guess?
Yes, hi, Molly Fidel.
Thank you. I have, sir, you're labeled as M2B5.
Yes, my name is David Bryant. I'm with the Attorney General's office.
Okay, I'll get that fixed for you if I could. Everything is so tiny when we have a lot of people. You said David Bryant?
Yes, exactly.
Excellent. I have a Miss Susan Watson that doesn't have a video right now.
I'm sorry about that. I must be having technical troubles. I'm sorry. I am in-house counsel with HHSC.
Okay, if you want to try to get that working, or if you need to leave and come back in, I can let you right back in. The judge will want you to have your video on if you're going to participate. If you're not going to be speaking, you can also watch on the live stream. Either one is fine with us. I don't know your role. Oh, there you are. It's like a miracle. Okay, sorry. Cynthia H, I have.
Yes.
Yes, ma'am, can you turn your camera on, please?
I am working on it. If not,
Okay.
I'll watch from the live stream.
And I have a Jessica Ibarra. I think you emailed me earlier. If you're going to be part of the hearing, you would also need to leave your camera on unless the judge gives you permission. I have someone named Jim I'm going to let in right quick before we start. All right, I have someone named Jim who's joined the YouTube. Can you get your camera on for me, please?
I don't know if we can hear me.
Hi, Jim. What is your last name? Oh, you're on mute still. Sorry.
Rich. I'm just observing today.
You're just observing. How do you spell your last name?
RICH.
Oh, gotcha. Sorry. Okay. I think I've talked to everybody. Again, if anyone's having issues and are not going to be speaking, you are welcome to watch on the live stream. We have looked and it is working. Cynthia left, so I'm going to let her back in.
Shannon, may I interrupt? Is there any way that you could perhaps drop the link to the live stream?
Everything on here, the chat is closed off so that people can't do commenting. If you Google 459th District Court YouTube, it pops right up and it should be already streaming so you can start watching it right away.
Excellent. Yes, ma'am. Thank you.
Okay. All right. With that, I think, okay, we're going to go ahead and get started. The 459th District Court is now in session. The Honorable Judge Maya Guerra-Gamble presiding.
Good afternoon, everyone. Welcome to the 459th District Court. My name's Maya Guerra-Gamble. I'm the judge in here. I see right off the bat a couple of problems. I see way more people than I think are going to be talking. And so if you're not talking, please go to YouTube. I see people who might be attorneys or might not. And he's gone, so I don't need to worry about that. Okay, so attorneys, of course, dress professionally, which was where I was going with that. Ms. Jahangiri, all I can see is half your face. So you're going to have to adjust your camera if you'd like to stay. Are you working on it? You are on mute, which is fine, but if you're trying to tell me something, I cannot hear you. Okay, I guess she's decided to leave. That's also acceptable.
I just got a text from Mr. Baruch who said the YouTube channel shows nothing right now.
Well, is he in the 459th?
No, he's counsel, but he was driving, so he obviously elected to be in the YouTube to watch it from YouTube.
Yes. So, all right, hang on. We might hear something, but
it is up. We have somebody in our office on the YouTube channel.
We could see it. So, but I'm just going to confirm, since I am directing everyone there. Just give me a minute. My computer just is acting very strangely now. Mr. Snell, you said you have somebody in your office currently watching on YouTube
That's correct, Judge.
and it's
and
working.
It's working just fine. We can
And I
see.
was told that it's now working.
Yeah. So YouTube is a weird one. It has a little delay. And that's why we turned it on before the hearing started. So I'm just going to check one more thing. All right. So this is perfect. Okay.
You're
Everyone
right.
who is here the way I like it. So as a reminder, I don't have a court reporter, so there isn't a record, but it's technically an ex parte TRO and no record is required. So we're going to go ahead and proceed. I did have my staff warn everybody about that yesterday. All right. So we are here on, oh gosh, D1 GN 26002511. I am not reading that caption. I'm going to call it the Texas hemp businesses versus the state for now. Somebody else can read that entire caption if they want to, but I would like announcements for the record, please, starting with the plaintiff side.
On behalf of certain plaintiffs, Texas Hemp Business Council, Alchemy TX Consulting LLC, A to Z Investments and Wholesale, CPRT and Company LLC, and Texas Green Craft LLC. My name is Jason Snell, the Snell Law Firm. On behalf of those same parties, we have Amanda Taylor and J.R. Johnson from Butler Snow and Andrea Steele from the Banks Law Firm.
Okay, is she here today? I don't see her.
I don't believe she is.
Okay, that's fine. I just wanted to make sure I wasn't missing someone I should have been able to see. All right, then from the other side.
Actually, we have two more plaintiffs, Your Honor.
Oh, I'm sorry. Go ahead.
Mr. Alvarado, I think you're first in the line.
So Andrew Alvarado from Dickinson Wright, here on behalf of Plaintiff, Hemp Industry and Farmers of America.
And David Sergi, appearing for Saganic Services, Inc., Elevate One LLC, and Texas High Council LLC. And joining us on YouTube is Mr. Chad Baruch.
Right, he's in a car. I definitely do
Yeah.
not let people drive and appear in the courtroom at the same time. That seems like a lawsuit waiting to happen. All right. Mr. Berg or Mr. Dustin?
Yeah, Zachary Berg from the Office of Attorney General. I'm joined by Mr. Dustin. Mr. Bryant was with me as well. We represent Jennifer Shuford in her official capacity, Stephanie Muth in her official capacity, and Ken Paxton in his official capacity.
All right, wonderful. Okay, who's going to take the lead on going through this request today?
Judge Jason Snell, I'll be handling argument primarily on behalf of plaintiffs. I may ask Mr. Johnson to assist if Your Honor has any technical questions concerning either the rules or some of the testing standards, and then Amanda Taylor may respond with any questions concerning jurisdictional and other questions of law.
Okay. Well, I'm going to turn it over to you and leave it in your hands to tell me what you want me to know. I do, before we get started, want everyone to understand that in the clerk's file, there's only the petition. So I don't know if anybody filed anything else. I've read that. So anything else from the other side, Mr. Berg? You haven't filed
No,
anything?
Your Honor, we just got this yesterday.
Yeah, I know, because my office contacted you as a courtesy, basically, and because I think it works better to have both sides present at something like this. So
We agree, and thank you for the consideration.
okay, thank you. All right then, Mr. Snell.
Judge, if I may, I believe that the only filing that has been made is the plaintiff's original petition, and then we filed some returns of service either yesterday or today. I don't remember when those were filed, but I don't believe the defendants have filed anything. We did submit, along with our petition and via email as well, and I think uploaded to Box a proposed temporary restraining order.
I do
don't
have
know.
that. You
Okay.
gave me two. I printed out the second one.
Okay, thank you, Judge. I also earlier today, we sent over and I believe uploaded to Box a demonstrative aid. It's a one-page document that with some columns on it. I don't know, has Your Honor had an opportunity to open that document?
No, I did not look
Okay.
at that yet.
Okay.
I saw it,
and
but I didn't look at it.
Okay, thank you. And I may show that during my presentation at some point. And the purpose of that is just to try to distill some of these arguments into a digestible form and to show Your Honor and provide an example as to the effect of some of these rules. I'm gonna refer to those as the illegal rules today, and because we do believe they're illegal. At the end of today's hearing, Your Honor, we're going to ask that you enter a temporary restraining order consistent with the form submitted with your that has been previously submitted to the court. And my argument is going to, for the most part, follow the form of that order, if I may. First of all, I want to make clear that there's nothing in this pleading, there's nothing that we're going to argue today that is intended to be any kind of policy debate. So, you know, there are people on both sides of this discussion with respect to hemp products. They may or may not want to see these types of products on the shelves and believe in certain kind of regulations should or should not apply. That's really not what we're here for today. And this lawsuit does not seek to engage in that policy discussion in any manner whatsoever. This lawsuit is really based on a constitutional separation of powers issue. And what do I mean by that? What I mean by that is this. The Texas legislature was very clear in 2019 when they passed a HB 1325. HB 1325 established a specific compliance metric to determine the type of hemp products that would be available to consumers in the state of Texas. And that involved, and this at some point is going to get technical, but that involved a Delta-9 THC concentration of not more than 0.3% on a dry weight basis. That regulatory structure and scheme has been in place since 2019. And as the affidavit testimony attached to our petition establishes, since then, for 7 years, the industry has grown up around it in the state of Texas, resulting in millions, if not billions of dollars in tax revenue, revenue in the state of Texas, tens of thousands, if not hundreds of thousands of jobs, and has created a marketplace for consumers of products who desperately need these products. The affidavit testimony establishes that the veteran population in particular and other consumers rely on the products that are legally sold in the state of Texas. And why is that important? Why is that's important in that this lawsuit seeks to establish the pre-March 31, 2026 status quo. On March 31, 2026, certain illegal regulations went into effect. And what did those regulations attempt to do? Well, those regulations attempt to do what the legislature could not do and did not do. In 2025, during the regular legislative session, legislation was brought up and passed by and vetoed by the governor that would have implemented some of these regulations that the regulators have attempted to now put in place, the illegal rules. So the illegal rules attempt to do what the legislators did not do. Governor Abbott vetoed the legislation. And then there were two more legislative sessions, both of which were called, at least in part, to attempt to enact hemp legislation or legislation that would regulate to a different degree the hemp products that we're going to be discussing today. Those special sessions did not result in new legislation. So here we are today with the regulators attempting to do what the legislators could not and did not do. And that's illegal. And that's what we're going to talk about today. So despite 3 legislative sessions, these restrictions, these illegal rules did not go into place that the legislatures are now attempting to enforce, which are in effect as of March 31, 2026. Rather than accept the result of what happened at the Capitol, DSHS and HHSC embedded the very standard the legislature declined to enact, a total Delta 9 THC conversion formula. And what that formula does is this: it turns what are legal hemp products into illegal hemp products. So these same products, such as, and we're going to talk about it in more detail later on in the hearing, such as ointment, for instance. Well, ointment that is on the shelf in stores and marketplaces across Texas that is legal under the statutes passed by the legislators is now illegal because of the bizarre testing standard that is now in place that now Frankensteins these products into alleged illegal products. And that's an unlawful exercise of their powers, and it's unconstitutional. And this lawsuit seeks to redress that. The Texas agencies, as your honor knows, may only exercise the authority that the legislature delegates to them. What the legislature refuses to enact cannot be imposed through rulemaking. So the rulemakers cannot overstep their authority and enact rules that are more restrictive than what the statutes, than what the legislatures have enacted. And courts have repeatedly enforced those structural boundaries. That's a separation of powers issue that falls squarely in your honor's court. And so again, this lawsuit seeks to preserve the status quo, the pre-March 31, 2026 status quo, and to keep in enactment or keep in force the lawful governing hemp standards that are in place, that remain in place, that were passed into law in 2019, that Governor Abbott refused to change when he vetoed the proposed legislation back in 2025. Now, I do want to highlight some facts that are illustrated and attached to our petition because I think they're important. And I'm not going to go to a great length on this. I just want to highlight some important facts for your honor. These plaintiffs are licensed, compliant businesses and trade associations that are legal, lawful, follow the rules, and do the right thing. They have invested millions and millions of dollars in reliance on the 2019 statutory framework. Mark Bortis's affidavit in particular goes to great length to talk about the great economic impact on the state of Texas. The state of Texas itself and Texans as a whole, billions of dollars of economic revenue, jobs, sales tax revenue, wages paid, and workers employed due to the industry that has sprung up as a result of the legislation in 2019. We're asking your honor to restore that, to keep that in place because it's so important and to prevent these unlawful rules from remaining in effect. The illegal rules effectively ban legal products, legal hemp products, by using this Frankenstein testing formula that turns these legal products into illegal products. And I used the example a moment ago about the ointment because it's so absurd. The new testing requirements take this ointment, heat it, and it results in this formula that says the ointment that you put on your skin to ease pain or whatever else turns it into an illegal product. It's silly. It's silly and it's illegal. Additionally, so we're asking your honor to restore the legal testing standard, Additionally, fees that we're going to discuss in a minute have increased. And in some cases 40 times or 67 times prior levels, with no demonstrated cost recovery basis or value added service provided by the state. Those fees are illegal. $10,000 fees per store per year, $5,000 fees per year, up from $250, hundreds of dollars into tens of thousands of dollars. Those fees are illegal. They're prohibitive. And I'm going to talk about that. And the affidavit testimony talks about that. There's daily accrual penalty structure that exposes businesses and individuals to escalating fines before they can receive the notice and cure protections that the legislature has mandated. That's illegal. That's an illegal fee structure. If this TRO is denied today, Judge, and these illegal rules are allowed to remain in place, many plaintiffs, and some of whom have already had to do this, many plaintiffs will be forced to cease operations, to destroy inventory, to sever supplier relationships. These are harms that cannot be undone. And I posit to you, Judge, this is exactly the situation. And I'm going to talk about this in more detail, obviously. But this is exactly the situation where injunctive relief is textbook. Why that is a remedy that is appropriate in this case. Thousands of people lose their products, their lifetime investments, their businesses, their jobs, everything they poured their heart and soul into. Those are already going away and could be gone forever unless this illegal regulatory framework is stopped. And Your Honor has an opportunity to stop that today. Now, I do want to make one thing very clear because it is important. This is an industry, it is not the Wild West. This is an industry that is highly regulated, and proudly so. The industry supports that. For instance, nobody on plaintiff's side would ever argue with any of the legal regulatory regulations that are in place today. For instance, age verification requirements and other consumer protections that have been in place since 2007. The plaintiffs in this case and others protected that will be hopefully protected by this TRO entered today embrace those protections and comply with the law. This lawsuit doesn't seek to quibble with any of that or upset any of that. In fact, we support it, and that's important. I want Your Honor to know that. Now, I know, having been in your court a number of times, you've read the briefs, you know the law as well as anybody else, but it's incumbent upon me and my clients to establish that we're entitled to a TRO. So I do want to explain in some amount of detail why we meet the burden necessary for Your Honor to enter the TRO in the form that we've submitted to you, which we ask that you'll sign at the end of the day today. We bring numerous causes of action. We'll establish a probable right to relief on the merits for every single one of the causes of action that we bring today. The first claim that we bring is an ultra-virus claim. These, and I've talked about that, the rules that were enacted exceed the authority of these rule makers, of the defendants in this case. The agency did not simply implement rules for Texans to follow the statute. The agency attempted to replace the law as it stands right now. The rules attempt to replace the law. The statute measures Delta 9 THC only. That's the testing that under the law is required to be performed to determine whether a hemp product is legal or illegal in the state of Texas and can make its way into the marketplace. Well, what have the rule makers done that it's in excess of the law? What they've done is, and I talked about this, the rule creates a new testing methodology that Frankensteins these legal products into illegal products. It substitutes that lawful formula with a different formula, a total THC formula. And that's a different standard than what the legislature enacted and what the governor refused to change last year through 3 legislative sessions. So that's the first claim, the ultra-virus claim. And we believe we're gonna, that our pleading establishes a probable right to relief on the merits of that claim. The second is an unconstitutional occupation tax. And that And we go through that in our petition. The fees increased 40 to 67 times with no relationship to program costs. The agencies admit that the costs annually with implementing the rules are about $70,000, about $70,000. And the permit fees and the other fees that the new rules or the illegal rules ask our clients to pay are hugely in excess of that and will go into the general fund, not even make their way over into the agency's fund to administer these illegal rules or to implement any enforcement mechanisms. That hasn't happened. And that's an unconstitutional tax. And these fees function as revenue generation, not regulation, and that's illegal, Judge. And we have established a probable right to recovery on the merits of that claim as well.
Could you just say that last sentence again? The fees operate as what?
As revenue generation, not regulation. So the fees are just revenue generators and not as a method of regulation. So they don't fund regulation of the industry. They just operate.
That your argument is not allowed by the statute enacted in 2019 or some other principle?
Is not allowed by the Texas Constitution.
Okay.
Is not allowed by the Constitution. And Your Honor, the and the fees are essentially not only are they an unlawful fee revenue generators, they're also a almost a sanction or a barrier for entry into the marketplace. So whereas before the fees, the annual fees to operate a store, for instance, were hundreds of dollars, they're now several $1,000s up to $10,000 per year. Well, there's affidavit testimony attached to our petition that establishes that this is effectively a game ender for businesses. This is a sanction on these businesses. This is a barrier for entry, and it's an illegal fee, and it's going to put people out of business and has already. The next claim are these daily penalties that are going to be implemented and have been implemented and enforced for those individuals or these businesses that don't follow these illegal rules. And that violates the Texas Constitution, Article 1, Section 19. These penalties begin to accrue before notice and opportunity to cure. The statute requires that, the 2019 statute. And so the structure of these rules conflicts with the 2019 lawful statute. So the illegal rules conflicts with the statute that passed in 2019 that violates the Texas Constitution. The next claim are these excessive fines, daily compounding penalties, combined with embargo and licensing consequences that can be business ending. And these penalties are disproportionate and unconstitutional as well, violate Article 1, Section 13 of the Texas Constitution. There are also Administrative Procedure Act violations. The agency failed to prepare a required employment impact analysis, consider less burdensome alternatives, and failed to respond meaningfully to comments. Now, each violation independently supports invalidation of these illegal rules. Each one of them does, but we meet the standard with respect to each cause of action. Now, again, I talked about this a moment ago with respect to the probable, imminent, and irreparable harm, and that's set forth in the declarations. And I apologize that this was a more than 300-page filing, but we wanted Your Honor to have the opportunity to have these affiants in front of you so that you can see this impact that these rules are already having on hardworking tax-paying Texans. And it's happening, it's rippling across the state of Texas. And you have that affidavit testimony in front of you. And these are not hypothetical harms. These are real harms that are occurring. This is not just probable and imminent harm, which is the standard. This is actual irreparable harm that is already occurring and that is exponentially multiplying, like a wave rolling into the beach that gets bigger. That's what happens every day. The wave is getting bigger as it rolls into the beach. And so we're asking you to put up a barrier. Every day without relief, the affidavit testimony establishes that these businesses are losing goodwill, they're losing customer relationships, their product is coming off the shelves. In some place, it's having to be destroyed. And these are people who the affidavit testimony establishes have invested, in some cases, their life savings into their product and into their businesses. And it isn't just that this is happening, causing this economic harm. It's that this is happening and causing economic harm in an environment where these people don't have recourse. It isn't the typical situation, as Your Honor knows, where this millions of dollars of damages occur. It occurs, you quantify it, you get some kind of expert report, you file a lawsuit, and you recover your damages. Well, if that were the case, of course, we wouldn't be here today, and a TRO wouldn't be the appropriate remedy. We can't do that. These defendants are sovereign. We don't have economic resource. So the economic harm that occurs is irreparable. And again, this is why this is a textbook TRO injunctive relief case. Additionally, plaintiffs cannot import, because of these illegal rules, cannot import hemp plant material for processing. And so this is effectively not only shuttering businesses that are consumer facing, but the industry that backs up those businesses. So the manufacturing facilities, the growers, the farmer in East Texas. And we have her testimony. I believe her first name is Lauren. Her last name escapes me, who talks about her business in Longview that she has set up, and she tells a story about how she sets up next to the courthouse and markets her products, her ointments and things like that to people that need them, and her growing facility and her great relationship with law enforcement. That investment on both the front end and the back end and that's just an example, that's happening all over the state of Texas. That's being shuttered perhaps permanently every day that these unlawful and illegal rules stay in effect. And again, that's something that the consumers don't see, but that the industry feels, the growers feel, that the East Texas or West Texas, wherever you may be, they feel it every day and they're feeling it. And there's no adequate remedy at all. And I touched on that. And that's a third element of this TRO relief. Our clients can't come in and seek redress in Your Honor's court or in any other court once these economic harms are befelled upon them. And so that's just not an option. So there is no adequate remedy. Now, we do have to establish this balancing of equities, okay? So on the one side, the plaintiffs and those others across the state of Texas who would benefit from this TRO on the one hand, and the defendants on the other. How do those equities balance? And how does the public interest weigh in and filter through that? So I'm going to talk about that now. And I've talked about the business closures and this court's opportunity to stop that from happening. Those equities weigh in favor of the plaintiffs and those affected by this lawsuit who will benefit from it. The destroyed inventory, the lost customers, the supply chain collapse, perhaps permanently, shuttering businesses, the businesses that have frankly just moved out of state, across state line, okay? And if they can, most of them can't. If they can, they will. And so we're losing businesses. And that's in most cases, or at least in many cases, irreversible damages. So those equities weigh in favor of the plaintiffs. On the defendant's side, there's absolutely no cognizable harm to the defendants from maintaining the pre-March 31 status quo while the validity of this illegal rules is being litigated. And that's what we're asking. So There's no harm to the state of Texas while this litigation plays out. If your honor should choose to enter a TRO and then later, perhaps your honor or some other court enter a TI until time of trial, there's no harm to the state of Texas. And then, of course, there's the public interest component of this, which perhaps is just as important and maybe more important than anything else I want to talk to your honor about today. And the affidavit testimony gets into great detail about this, about the consumers. The consumers of many of these products are the chronically ill, those who use these products not for some purpose other than to ease their pain, help their ability to sleep, help their ability to just engage in the activities of daily living, not for some other reason, but for that reason. And the veteran population is disproportionately affected by this. Studies have shown that, and the affidavit testimony establishes that, both through the fact that our veterans have needs that often aren't met due to whatever trauma or injuries they've experienced. These products that are lawfully on the shelf for the last 7 years have greatly benefited that population. And frankly, that population is not only so important to these consumers, but to the affected parties and to the plaintiffs, but that's a demographic that spoke to the legislator and spoke to Governor Abbott, that the veto stamp went on the legislation. That was a population that was important when considering all that. And so I ask that your honor consider that, and I know you will. And again, it's not just that population. It's those who have the ability to utilize these legal products to help them in all manner. And frankly, unfortunately, if these illegal rules remain in effect, there is going to be a segment of that population of the chronically ill, the veterans, who may in fact turn to illicit products. Now that's an outcome that is completely avoidable. That's an outcome that is avoidable and should be avoided, is forcing some veteran to whereas before had an opportunity to purchase a legal product under the legal statutory framework, to go to behind the dumpster at some store and engage, and purchase some illicit product. And nobody wants that. My clients certainly do not want that. The legislators don't want that. No party wants that. Certainly this consumer population doesn't want that. And this litigation, in some part at least, seeks to avoid that. And it is completely avoidable. In this illegal framework, these illegal rules, the impact of that does that. And that's ridiculous. And we ask that your honor avoid that and not do that. And so that is in essence the public interest argument. And your honor, and I don't want to belabor any of these points, but I just do want to add a few things. The rules of operation is clear. These illegal rules, the operation is clear. They embed a different compliance standard, different than what the rules, what the legislators, and what the government signed into effect did. A different standard. This different standard, this illegal standard, takes legal hemp product, hemp plant that enters into the marketplace, before it enters into the marketplace, and Frankensteins it into illegal products. So these rule makers, exceeding their authority, have enacted this new testing standard that does that. And that's illegal. That's not the implementation of the law, which is their job. That's changing the law, which is beyond their job, which is unconstitutional. That's illegal. That's an illegal and ultra-virus use of their powers. The DSHS has acknowledged in its own rulemaking record, that changing the THC standard requires legislative action. They've admitted that. Changing the standard requires legislative action. And the legislators have in 3 sessions been unsuccessful in doing that. And the governor vetoed it. They came back to 2 special sessions, in some part to attempt to enter new or enact new statutes that would further regulate the legal hemp industry. And that's important. The reason why I say it that when the governor called these 2 special sessions, and I'm paraphrasing here, the purpose in some part was to attempt to regulate or further regulate the legal hemp industry, not regulate it out of business, not regulated out of business. Had he wanted to do that, he wouldn't have vetoed that legislation, which perhaps would have done some of that, but that's not what happened. But that's what the agency has attempted to do, and that's unconstitutional. And again, those fee provisions are untethered to regulatory costs. We have evidence of that. A 40-fold fee increase against a rulemaking record showing a program cost of tens of thousands of dollars is not a cost recovery measure. It's an illegal occupation tax, is what it is. And these violations are not technical. They are substantive. The agency failed to do the required local employment impact statement, failed to consider less burdensome alternatives, failed to substantively respond to statutory objections, and each of those is an independent ground for invalidation. And again, we don't come into this court with speculative harm. We come into this court with evidence of concrete, everyday harm. That wave rolling to the beach that gets bigger, that's the harm every day. And our affidavit testimony establishes that. But it's not speculative or hypothetical harm or wishful thinking, or I should say nightmare thinking. That's not what that is. We filed a 300-page document that documents the harm that's occurring to Texans, tax-paying, law-abiding Texans every day. And those are in effect. And again, the affidavit testimony establishes the harms occurring to our clients, our businesses, our consumers, the veterans, the chronically ill, all of these people, the loss of goodwill, loss of community businesses, loss of lifetime investments, loss of opportunity, loss of a dream, frankly. That's all happening every day. The destroyed inventory is gone. The relocated manufacturing operations may not return. And again, the defendants lose nothing of substance if Your Honor enters this TRO today. Nothing. All that happens is that the lawful regulations, the lawful statutes remain in effect, and we go and have our TI hearing within the next 14 days or whenever we can make it happen. That's all that happens. There's no harm to the state. The balance of equities, and I went into that, favors the movements in this case to an exponential degree. And to the contrary, we stand to lose our businesses. Our plaintiffs suffer. And frankly, the public interest is served by this. And I walk through that, and I don't want to belabor that point, but the public interest favors these legal products remaining on the shelf for all the reasons that I've already discussed. And I've discussed the veterans, the chronically ill, the people who rely on these products, not for recreational purposes necessarily, but for purposes that are genuine, health-related, beneficial to their lives in a manner that is productive for society and healthy for all of us, frankly. And there are no alternatives. And this is a regulated industry. So it isn't the case, Your Honor, where I'm asking you to send us into the Wild West. That's not even close to the case. I'm asking you to send us back to the March 31st, good old days of March 31st, into a highly regulated past, into a highly regulated industry, a regulated industry that our clients embrace, that our clients follow the rules, that our clients adhere to. That's where I'm asking Your Honor to send us today, and nowhere else. And again, this is an economy, the Texas hemp economy that has sprung up, a lawful economy that has grown, resulting in millions, if not billions of dollars, both in tax revenue, in business generation, in jobs. That is what is at stake. And that's the status quo. That's the status quo. So, Your Honor, at the end of the day, I am asking you to restrain enforcement of the various rules that are outlined in the Texas Administrative Code that are outlined in our proposed temporary restraining order. I have and we have narrowly tailored our request today. We don't believe it's overbroad in any sense. And I would, if I could, Your Honor, may I share the one-page demonstrative
Okay.
aid with the court?
Absolutely.
Okay, thank you, Judge. And I hope after these many years of being on Zoom, I'm successful. Okay. Are you able to see that, Your Honor?
I am, yes.
Oh, okay. And I'll be the first to admit that when it comes to technical things, I'm not the best person. J.R. Johnson probably is on our team. But I've put side by side the legal standard on the left. That is the pre-March 31st standard, the legal standard. The illegal standard is on the right. And so on the left, we have what the legislature has required. On the right, what the agency requires. And I've talked about the Delta 9 THC as opposed to how on the right, how the new rules count it and how it's measured and what the compliance standards are. And again, that may invite some technical questions, but I just wanted Your Honor to have an opportunity to see it side by side. And then what I've tried to do, Judge, I've tried to, the next piece of information on here is the testing at the manufacturing stage. And so, and I'm going to try to, because I'm not that smart, I'm going to try to make it as simple as possible because that's the only way I can understand it. The pre-harvest hemp, so the plant, is tested under the agricultural code and deemed lawful if its Delta 9 THC is 0.3% or less. So you take the plant, you test it. If it's 0.3% or less, it's hemp. If it's greater than that, it's not hemp. Okay? It cannot enter into the marketplace. Number two, that material moves into manufacturing under the health and safety code. So you pass the test, which our clients adhere to, and they do. If it's 0.3% or less, it enters into the manufacturing. The illegal rules then require retesting, require it to be retested after it's entered into the marketplace. And pursuant to these tests, on many occasions, a lawful hemp plant is then Frankensteined into an unlawful plant under the illegal rules testing because of the way they're tested. So you test it, it goes into the marketplace or it enters into the stream, but then you test it again under these illegal rules. So you take the ointment that I use as my example. You take the ointment that is selling on the town square out in Longview, Texas, that you rub on your skin. Under these new rules, you heat the ointment. You heat the ointment, and then you test it again. And then, under these illegal rules, that's illegal. You can't sell it. It's got to come off the shelves. If you do, we're going to hit you with these fines. You've committed an illegal act. You've committed it. And by the way, even to do business under these illegal rules, we're going to make you pay several thousand, $5,000 to $10,000 a year just to do that under these illegal rules. Okay, and so as a result of this, the manufacturer cannot use otherwise legal ingredients. So we've taken legal hemp, we've perverted a test and Frankensteined it into illegal hemp. And then the manufacturers, they can't use it, and it's upset the marketplace. And so what has happened? What is happening on the ground right now? Well, what's happening on the ground is right now a huge amount of confusion and uncertainty. Products are being shelved. There's great confusion about what's legal and what's illegal, what people can and cannot do. Businesses have stopped, operations have stopped, growers have stopped. The whole business has ground down. And that's what's happening every day. That's what's happening every day in the marketplace because of what I've just described in the middle section of this one pager, where I'm trying to do my best, and probably not a good job, of describing what's really happening in the implementation of these illegal rules. And so, and I've tried to use the topical hemp ointment analogy again, or example again, not an analogy, on my one pager, to make that to try to make it more clear as to how that works. So in reality, in conclusion, Judge, the product hasn't changed. So these legal products under the legal statutory framework have not changed, did not Frankenstein on March 31st. The lab results didn't change. Nothing changed. The product didn't change. The lab results didn't change. Only the rule for counting THC has changed, and when you count it has changed. And that has turned legal products, has Frankenstein them into illegal products. And that, amongst other things that we're seeking in our petition, is what we are asking Your Honor to restrain today for all the reasons that we've described. And unless Your Honor has any questions of me or Mr. Johnson on any technical grounds related to these testing or other issues, I'm happy to cede my virtual podium. And
you can take the screen down. It might not be relevant.
Operate a store, you could be somebody who has less than $5,000 in revenue, or you could be someone who is greatly in excess of that.
Okay, thank you. All right, Mr. Berg.
Thank you, Your Honor. We agree with the plaintiffs on a few things. This dispute mostly comes down to whether a cannabis plant is determined to be hemp or not based on the total amount of THC. Plaintiffs allege that under Texas law, only THC should be counted. We would humbly offer that the law prior to the rule was already that it was a total THC of THC plus THCA, and plaintiffs aren't actually challenging the administrative rule that governs on that. This all started really in November. Congress passed the Continuing Appropriations and Extensions Act, that's number 119-37, essentially clarifying the definition of hemp to include the THC's total, the THC plus THCA. So that was passed in November. That is effective November 2026. So regardless of however this turn,
It's not effective yet.
yes,
Okay.
it's not effective yet. I'll get to that. So in November 2026, all 50 states, that will be the rule period. However, states can't be less strict on testing, but they can be more strict on testing. So Texas is not in violation of federal law or in compliance with federal law. But essentially, that's where the language comes. That's why the November act and then rulemaking started in December. The rulemaking underwent the normal process. The rule explains the process, considerations, includes notice and comment. So that part's all good. Plaintiffs, obviously, I appreciate the situation that they feel they're in, but the testing of THC was already part of the rule governed under 4 Texas Administrative Code 24.26C. That was enacted through express rulemaking granted by 122.151 of the Agricultural Code. And that has been in effect and federally approved by the USDA as required by 121 since 2020. That is not challenged here. That will not change. That is the law, and that will remain the law. I encourage the judge. Sorry, I misspoke. 122.015 was the rulemaking. But anyway, the rule, the congressional rule, I believe, attempted to address what some considered a gray area, but as according to the law on the books, THC includes THC plus THCA, which can be converted to THC through heating. Both the federal rule that's coming into effect and the Texas rule contemplates that occurs at about a 87% rate of conversion from THC to THCA to THC. A couple things, plaintiff said that defendants acknowledged in the rulemaking that they were breaking the law or something like that. What they said was that they didn't have the authority to amend the agricultural code. Our position is that they don't need to. This is consistent with Chapter 443 of the Health Code and Chapters 121 and 122 of the Agricultural Code. We could walk through that if you want. Texas courts have already found that the THC includes the THCA total in Barlow v. State. That's a Court of Appeals for the 5th District of Texas. That's number 105-21-00392 CR. They found that THCA is included within the definition of hemp. So hemp says that, so it's plant cannabis and any part of that plant, including the seeds of the plant and all derivatives, extracts, cannabinoids, isomers, acids, salts, and salts of isomers. So the Barlow v. State case found that the acids included TCHA under the definition of hemp in Section 121. So on the books of how you calculate this, we have 4TAC 24.26C, which is how you calculate this. Then we have Court of Appeals for the 5th District of Texas, November 2022, saying that THCA is included within the definition of hemp, under acids, in calculating concentration of delta-9 THC. So I think at worst, the agencies are clarifying some ambiguity in the law, and at least how certain people have interpreted it. We don't think that it is ambiguous. Like I said, this has been the law since at least 2020. We're still researching. It might go back before 2020. But 2020 was when Texas, as required by 121, Texas is required to create and submit a state plan on hemp to the federal government, which sort of came out of all the legalization of hemp in the late 2010s. The federal government, the USDA, requires that each state submit a state plan on how they're going to test and do all this. So as part of that, in 2020, Texas submitted the language that was already in law at that point, 4TAC 24.26C, and that was approved by the federal government, and that has been the law since. And like I said, plaintiffs are not challenging that. That is a live law, and that was promulgated through rulemaking provided in statute. So that is all on the up and up. I'd like to go through, thank Mr. Snell for the little graph of all the claims. I was very impressed by his handiwork, although it may have been Mr. Johnson from what he said. I don't know. He said Mr. Johnson's pretty handy. But whoever came up with this I thought was pretty good. The APA alleged violations that they make, essentially they're saying that due to comments that the agencies should have taken additional steps. I think that's in reasonable dispute as far as the TRO. I don't really think that goes to the TRO. I think that you can probably decide the TRO otherwise. Second, the dispute over whether THC includes just THC or THCA, which can be easily converted to THC through heating. I think that's the core of the dispute. And like I've said, that's been the law in Texas since at least 2020 has been that THC is THC plus THCA in a formula of approximately 87.7%. So what you do is you take the amount of THCA and you multiply it by 0.877, and then you add them together. What they call transport upstream material restrictions, those claims, those are, again, largely related to the dispute over total THC. The only reason that they're not allowed to transport these materials is because they're illegal. And if they're not illegal, then they're allowed to transport them. So it really turns again on the THC definition question. The fee and licensing regime, I'll admit we haven't had as much time to look into this. And if you wanted to do a TRO solely on the fees and licensing, I appreciate that they're large in absolute terms. Initial research shows that at least in amounts, they're similar to what New York charges. New York and Texas are reasonably similarly situated states. Texas is the second largest state. New York's fourth largest, so we're a little bigger and better than New York. But I don't think it's a per se unreasonable to say that what New York is charging that would be per se unreasonable, which is the objection under 443. And then the penalty accrual framework, that was interesting as well. They cite at the bottom unconstitutional excessive fines. They cite to the Pennington v. Singleton case, which is very interesting. Well, to me, it's a DTPA case, Deceptive Trade Practices Act, and I started in consumer protection, so I saw that and I was like, oh, that's interesting, because I usually don't get to come across consumer protection cases in my current role. So I did appreciate that for plaintiffs. But anyway, so that's a 1980 Texas Supreme Court case where the question was whether the DTPA, which at the time allowed treble damages in certain situations, whether that was penal in nature and subject to constitutional requirements of penal statutes. And the Texas Supreme Court actually found that it was not subject to penal statutes. So it seems in opposite to plaintiff's point that these fines or that the penalties are so extreme that they should be given penal status. Certainly we'll keep exploring that, but we thought that was interesting. One, consumer protection I was excited to see, and then the case seems in opposite to their point. I think maybe I can answer some questions if you have. I think just to reiterate, at least as far back as 2020, the current rule has been the law. The current rule provided clarity, which clearly there is a lot of confusion. Certainly just if plaintiffs are able to generate 330 pages, which I'm not complaining about generally because I appreciate thoroughness. But if they're able to generate that much of people saying that, no, we disagree, obviously there was a case for more clarity in the law. but the law is, at least for the last 6 years, probably more. We'll keep researching that. But the law is that when you calculate THC, that's THC plus THCA. And that's not challenged here, and that hasn't changed.
But you, unless I misunderstood you, you only referenced me to federal sites in that entire part of your argument.
Oh no, that's a Texas administrative code. That's for TAC 24.26C. So that was sorry, let me try to explain better. I'm sure I stepped on myself the first time.
Well, you just said you cited a lot of numbers. Sometimes when people are in front of me and they do that, I say, I have 20 books back here and I don't know which one you're talking about. And you had started by referencing a new federal law that's not in effect, some federal courts, and things like that. So I just kind of assumed you were still talking about some federal laws. So if I was wrong about that, yeah, you might.
No, I appreciate the feedback. I always appreciate and try to take any feedback a judge gives me. So essentially, there's 3 Texas statutes that are issue. Texas Health and Safety Code 443, and then the Agricultural Code 121 and 122. Those are the only Texas statutes really at issue. Then we have Texas Administrative Code. That's for TAC 24.26C. So that says the testing methodology must consider the potential conversion of, it's the long chemical name, but of THCA in hemp into THC, and the test result reflect the total THC derived from the sum of the THC and the THCA content. So we read that as saying that THC includes THC plus THCA content, because that's what it literally says. So where that loops back into the federal law again is that under Agricultural Code 121, Texas statute, the state is required to submit a plan to the federal government, because you used to not to be able to sell hemp. It was just basically all, they said, well, this is all marijuana and you can't do all this, and it's all Schedule 1. Late teens, they legalized hemp, big industry, obviously. So they submit the rule that was approved in 2020. So how we know that for Texas Administrative Code 24.26C has been in effect since at least 2020 is because that's when it was submitted to the federal government and approved. So that's how we can date it to at least 2020. So here we have the rule, agencies must enact rules consistent with both state and federal law. As I touched on earlier, the state law must be at least as restrictive as federal law, but it can be more restrictive. It can't be any less restrictive, because we're coming from the history of this was once all marijuana and now some of it's hemp, but like there's a cutoff line somewhere, and we have to establish what the cutoff line is, because some things good and some things, if we make it too available, there's public policy issues that we don't need to get into here, and which we may disagree on personally. But
I don't have any opinions on that.
I strangely don't. Parenthood has made me very boring, but I love it. But yeah, so we have the Texas laws, which under Texas law, how you calculate THC is THC plus THCA with a formula. It's times plus 8 times 0.877. But anyway, so that is what the new federal rule that's coming in is. And in November, that will be the rule everywhere, period. So plaintiff said something like, business are just going to move across the border, or just going to move across state lines. Well, not in November, they're not. So our position is that the rule is consistent with Texas law at least through 2020. Plaintiffs have not challenged that. I'd like to also sort of touch on the separation of powers that plaintiffs made. Sort of made it sound that the agencies were attempting an end around on Governor Abbott. That is, we have a somewhat different interpretation. So we have we have the Commissioner Shuford, who less than 2 years ago, Governor Abbott appointed to lead the state task force on infectious disease preparedness. And then we have Executive Director Muth, who was appointed December 3rd of last year to head HHSC. She's been there for a while, but Governor Abbott appointed her for that. December 3rd is important because the rule was proposed on December 15th. Plaintiffs would have you believe that Executive Director Muth acted contrary to Governor Abbott's wishes on a high-profile issue immediately after he appointed her. I don't think it's a reasonable interpretation of the timeline. I think a more reasonable interpretation of the timeline is that the person he appointed in one of our first acts on a high-profile issue was not acting contrary to the governor. Plus, Governor Abbott's veto was based on federal law, which had not yet been clarified. Texas law had already been clarified, and at least as far back as 2020. But you have the act that we talked about that where I confused you about thinking that all this was federal, which I apologize again and appreciate the feedback. But so Governor Abbott, this all came up on the legislative session. He vetoed that because his understanding was that it wouldn't have been consistent with federal law. And as we've talked about, state law, this all comes out of the regime where hemp was legalized, and state law has to be consistent with federal law. And in fact, it's required to submit a state plan to federal law for approval. So I think that's what he said at the time. And so we think that's perfectly consistent. And it makes sense that the people that he appointed and who he's put into positions of leadership are not acting contrary to his wishes.
All right, thank you very much. Mr. Snell, are you going to reply, or did you want somebody else to?
I do want to make a couple points, and then maybe Ms. Taylor or Mr. Johnson may want to add something or may not. I thought it was, and Mr. Berg is obviously a very good attorney. It's always nice to litigate against a very good attorney. It's a pleasure. He raised the point that the regulations were an attempt to, I think he said, mirror federal law, which may or may not go into effect later this year. Well, I think that highlights exactly our point, is that you potentially, we don't, the federal law may or may not go into effect. I don't know how that's relevant today, except for the point I'm going to make, is that if the rule makers attempted to pass a rule scheme or this illegal scheme in an attempt to mirror the federal law that may or may not go into effect this fall, that illustrates our point. That is, in effect, trying to make into effect new legislation, and that's illegal, and that's what we're stopping. And that illustrates our point. So whether or not this new federal law goes into effect or not, I don't think impacts this litigation. That's speculative and uncertain. And even if it shall go into effect in December, again, I'm not sure how that impacts this lawsuit, if it does at all. And I suppose as this lawsuit trucks along, if that does go into effect and it somehow does impact this litigation, that argument can be made at that time. So I wanted to make that very clear. And I'm not sure if Ms. Taylor or Mr. Johnson have anything else to add or not. They're obviously very good attorneys, unless Your Honor has any questions of us.
Well, I might, but I like to save my questions most of the time to the end. Sometimes I can't help it because I'm
I understand.
I need, help. But Ms. Taylor?
Good afternoon, Your Honor. I just wanted to clarify one quick point. The state's argument that there's previously been a test for THCA and Delta 9 THC. We've heard the state say that's always been the rule. That is conflating a pre-harvest test under the Agriculture Code, which Mr. Snell addressed, that first we test the plant in the field, and that has a different purpose. Once we have that pre-harvest test, to confirm that the plant itself is hemp, that pre-harvest test is expressly passed along in the manufacturing process under the Health and Safety Code, which is section 443, 151, and 152. The legislature made very clear that the next steps in the process, those industry participants are entitled to rely on the initial pre-harvest test from the farmer. So now that we're putting in this, I appreciate Mr. Snell's term, the Frankenstein testing midway through the manufacturing process that was never contemplated under the Health and Safety Code for manufacturing, processing, and retail. That is the violation. We are not contesting the agricultural code testing requirement, which has been in place, but it has never applied at these later stages. And the industry has functioned extremely well and has been well regulated as hemp products under that testing mechanism. That's the status quo that we think should remain in place.
Okay. All right. Is that everyone? Mr. Sergey, did you want to say something?
Yeah, one point. First of all, New York City kind of reminds me of a Pace Picante commercial. Why are we talking about a recreational state where we're a hemp state? But more importantly, the Barlow case, it's interesting when you look at page 20 and 21, what you see is it's pure dicta, because to quote the judge, moreover, the concentration, both delta-9 THC and total delta-9 THC in each sample was significantly higher than 0.03. If you go back and look at it, it's pretty clear that these samples were illegal to begin with. And so it's really not even, it's just pure dicta here.
Okay, thank you. All right, let's take a look at the temporary restraining order, proposed order that I was given.
Your Honor, if I could just touch on one point that Ms. Taylor touched on that I don't think had been touched on before in the argument.
About the difference between the agricultural code and the health and safety codes?
Yeah, I'll just note that the health and safety code uses agricultural code's definition of hemp. So 443 references both 121 and 122, and that's why we were talking about the agricultural code. But continue. Thank you for your time.
I know everyone is now, we're in that phase where no lawyer wants to stop talking. I'm just going to tell you, you muted yourself. I was going to say, I had already, Ms. Taylor, my briefing attorney and I are talking via text while you argue, making sure I'm understanding or think I'm understanding what you all are telling me. And she and I had already kind of gone, didn't I just read like 20 pages about the difference of these two codes? So I think I got that. So my question, and it's a hard one, Mr. Berg, your side hates this question, but which parts of this, what I like to call kind of the preamble part of the proposed order, I understand you think I should deny the whole thing, but let's just assume that isn't happening. Do you have issues with any of that language in the first few pages?
Yeah, I'd have to go through it. I have a lot of tabs
You
open.
looked at it before right now.
I did. I have a lot of tabs open, which is the downside of the Zoom. I apologize.
Yeah. I'm no fan of Zoom. If you want me to make you come in person next time, I'm happy to.
Yeah. While I'm looking for it, I think first, the irreparability of money damages. I think plaintiffs concede that most of the harm is money damages, and that they say that part of the problem is that they'll have trouble calculating money damages. I would hypothesize that might be a place for an expert who could testify on that.
Well, okay. All right. I asked, so I'll let you finish answering. That's fine. You can. Okay. Anything else?
Yes. I apologize. I thought I had printed out everything. I printed out the wonderful charts. So I am trying to locate the order.
All right.
I guess while I'm looking for it, Another thing that initially stood out to me was the scope of the relief. Plaintiffs say that they were harmed, and then they said that the relief should apply beyond the plaintiffs because it also affects the marketplace and distorts the marketplace. I tried to follow that conceptually. If they're harmed by the changes, wouldn't they get a competitive advantage if only their competitors were harmed and they weren't harmed? So I didn't quite follow that argument. Mr. Snell, what time did you file that? Was that the
Are you referring to the order, proposed
Yes.
order?
Well, it's not
Well,
filed. We don't file proposed orders in Travis County. So it's in box. I saw it in there and it was emailed to my office, and I'm confident that everyone was included on any emails to my office. That's all right.
I'm sorry. I didn't get a box account.
Mr.
I was
Berg,
told a box account. Yeah.
stop talking. I'm gonna go through it.
Yes, thank you.
Okay, so, we don't have a problem with the parties. I'm gonna assume that. So then,
I did think it was odd that we don't have agriculture here, but other than that, no.
well, okay, I don't know. You probably represent everyone on that side. It's an ex parte hearing that I invited defendants to as best I could. I got kind of a slightly snarky response from your office about that I think I reminded you this was an ex parte and I want you here. So not you, but somebody, I don't remember who. So I don't know if you did not bring all the people that you should have brought or what, but we've got the people we've got here. I meant the parties listed in the proposed order match the parties in the petition. I noticed there was a non-suit filed, but I don't see that entity listed in the plaintiffs, so I don't think I need to worry about that. I've lost my spot for who it was, but I don't see them in here. I had just checked that, so that's fine.
And I have the order. I found the order.
Okay.
But we can still walk through just the same.
Oh, okay. So for the paragraph labeled 1, probable right to relief, I do think that language is appropriate. I'm reading it again for myself. Yeah, so page 1 and 2 seem fine to me.
I mean that's.
I think pages 1 through really most of the language that you included, Mr. Snell, in those first maybe 5 pages relates directly to the testing in the new rule. Would you agree with that?
Me or Mr. Snell?
Mr.
Yes, Your Honor. To a certain degree, yes.
Okay. So I agree, and I'm going to grant the TRO on all of the definition of THC testing. I have a few questions about the fees and penalties sections that we're going to have to talk a little bit more about, but I think the rest of this is probably all fine. So, when we get to page 6, which is where the orders you're asking me to issue start, defendants are restrained from implementing, applying, or enforcing any portion of the challenged rules that conditions the manufacture, testing, transport, distribution, or sale of consumable hemp products on compliance with a total Delta 9 THC or acceptable hemp THC level standard, rather than the 0.3% dry weight basis Delta 3 tetrahydrocannabinol concentration threshold enacted by the Texas legislature, including but not limited to the provisions identified below. So I think that's good. And that I'm granting. So then 2, definitions and embedded compliance standards. Defendants are restrained from enforcing, and I did not go look these numbers up, so I'm counting on the lawyers to have put the right numbers in here for the code.
For the rule that's in effect now.
Yeah, good.
300.
Okay. To the extent these provisions define or implement a non-statutory THC compliance framework, including the use of a total Delta 9 THC metric that converts THCA into Delta 9 THC equivalents. So I just want to make sure that the compliance framework language there is not making this order broader than I want it to be. So I'm in agreement with you on the definitions and the testing. Does that include the fees and penalties? Because if so, we may need to just break each section out for me to grant or not. What do you think, Mr. Snell?
I'm going to rely on Ms. Taylor to help
Okay.
me walk through your order,
Ms.
this
Taylor,
order
then.
with us. So your question is, does section 3 touch on the
2.
fee?
2.
Oh,
Where it's
section 2.
literally, it's just about the words compliance framework, because that's real broad as opposed to the rest of that sentence, which is more focused. And I know it's only for 2 weeks, but I do like to do things correctly. So
Me too, Your Honor. So I appreciate that.
it'll help
Under-
the judge who hears the TI hearing. So
Under paragraph 2, where sections 300.101, sub 1 and sub 45 are referenced, those are not about fees. Those are about the THC metric.
okay, then I think that's fine. All right, so then paragraph 3, testing and commercialization provisions. So again, we named some rules and require compliance with a total. So that makes sense to me. Otherwise, substitute and so those both sound fine to me and like what I'm willing to grant here. Transport and manufacturing
Your Honor, if
restrictions.
I could just touch on one point, I won't try to convince you, but just the required first bullet point, require compliance with a total Delta 9 THC standard. I understand plaintiffs to mean that the THC plus THCA standard, but their position is also that the actual standard is just THC, and I don't think it's properly defined that we don't want to accidentally enjoin the agencies from anything involving THC. Could we put it in a definition on that?
Is it defined in the rule that's referenced in paragraph 3, Ms. Taylor?
I actually didn't understand Mr. Berg's
Section.
argument. I'm looking at paragraph 3, and we are asking to restrain these defendants from enforcing those 3 rules because the rules require compliance with the improper total Delta 9 THC standard and substitute the improper THC metric. If I'm following, maybe what he's asking for is additional language at the end of the second bullet point that says
something like THC, total Delta 9 THC, meaning THC plus THCA or something like
but
that.
that's not what the statute requires, and that's our whole point.
Right. I think that's kind of the crux of the argument here.
Okay.
Okay.
Perhaps I misunderstood.
I think you guys
The
have
eviction
you
return.
have lots of time to figure it out before your next hearing and then before the hearing after that too. The way I read this, it matches what's in the pleadings and in the argument I heard today. If somebody disagrees with me later, okay. But I don't think this does more than it says it does. So I'm okay with it. So paragraph 4, transport and manufacturing restrictions. Okay, so hemp is allowed, so that's fine. So I think that one's all fine. Okay, so then we get to the parts where I have some more concerns. All right, so paragraph 5. So when I was looking at all of this yesterday and today, I did not see in the enacted statute the same kind of definition about what a fee or license or registration fee might be. So I think that the rulemaking authority may have more leeway here. Now, I did hear all of Mr. Snell's arguments about how those are they are exceeding what the authority is. And I think you should be free to argue that at the TI hearing when you can bring in some more witnesses and maybe some more legal experts to talk about that. But I think for today, that one I'm not going to grant. But the penalties and enforcement mechanisms, that is different. I think it's quite clear that you have to offer some notice and opportunity to cure before you can start enacting penalties. So that one, I am going to grant, number 6. And then I just was a little bit, I wasn't really sure. I'll be honest, I don't remember reading an argument, but it was a lot of reading that I did that specifically addressed number 7, where I need to issue a separate order telling them not to engage in enforcement actions if I'm granting the rest of the TRO. So I need somebody to explain why that is. What am I missing?
Your Honor, our intent was simply to make clear the types of actions being restrained, just so that the order is clear and specific as required by the rules, allowing a defendant to understand exactly what he or she is precluded from doing. But I agree with you that the foregoing paragraphs cover it, rule by rule, but this was more directed at specific types of actions.
Okay. I guess I'll leave it in and I'll just expect that to be better fleshed out at your TI hearing.
Understood. Thank you.
Okay. All right. When do we want, I'm not part of it. When do you want your hearing? So we have 2 weeks, unless you agree to do something else, but you don't have to make that agreement today. Does anybody have I'm going to open my calendar, so I'm going to be looking like off to the side a little bit. Where is it? So I can see. So today's the 10th. So 2 weeks is the 24th. Do you want your hearing on the 24th? Do you want it on a different day?
24th works for us, for me at least.
I was going to suggest the 23rd.
Okay.
23rd works with my Judge, is this going to be in your quarters or on the central docket?
It'll be on central, and I don't know
Okay.
where it'll go.
Okay. The 23rd works
Work for you. Does it work for Mr. Berg, Mr. Dustin?
Is this morning or afternoon?
Oh, I'm going to set it in the morning so that you have enough time. I don't know how much time you're going to announce for, but it could be extensive. So I'm going to set it at 9 a.m. so that you have enough time. So April 23rd.
23rd, I think would be.
Okay. So I'm going to, okay. Oh, this doesn't really help here. Okay. Your notice language is not quite up to date in this proposed order, and that's okay. I'm just going to scratch out where it says in the blank Judicial District Court of Travis County, Texas, and I'm just going to talk to all of you and make sure you all know we have what are we calling it? We have a master calendar, in Travis County. So some cases will be assigned to a judge the week before, and you won't know until the week before. And so it is incumbent on every lawyer to announce, according to our announcement local rules, which can be found online, stating exactly how much time they believe the entire proceeding will take. That means your amount of evidence and talking, the other side's amount of evidence and talking, and, you know, throw the judge a bone and give her a little bit of time to talk as well, right? Because sometimes we need that. And then you make that announcement, and then we look at who's available and appropriate, et cetera, to hear the case, meaning who's not in a jury trial or on vacation or whatever, and so that you definitely get heard. So that I need you to do that, announce. So where it says in the Judicial District Court of Travis County, Texas, I'm scratching that out because I don't know which courtroom you'll actually be in, but you'll be in Travis County in front of a district judge, which is what you are entitled to. So everyone knows about the hearing now on all the sides. And so I don't feel like I need to make anyone serve notice or an order to appear or anything like that. You know, you need to show up. If you need me to orally say everyone's ordered to appear, then everyone is ordered to appear. I would expect that to be an in-person hearing. I don't, you know, that's my expectation. It's set as in-person. If for some reason, all of you want it to be on Zoom, all of you can agree to that and make that request to the court, but I wouldn't do this one that way if it were me. Okay. Do you have a proposed bond amount?
Judge, I would propose $50, especially in light of the fact that Your Honor has struck through paragraph 5, which relates to the imposition of and collecting of the license fees. The state is not going to incur any damages related to this. So,
Mr. Berg?
That's fine.
Okay, great. I love it when people agree.
We try.
All right. Today is April 10th. It's 3:40 p.m. And I'm signing the TRO that we have just gone over with those edits that I made. So I think you would call this granted in part, denied in part. Good luck, everybody. Thank you for your hard work. I know it was a little bit tricky getting everything organized in here in front of me today, so I appreciate all the work everyone put into it. Thank you all so much. That concludes the proceeding. I'm not going to call it a hearing. We don't have a court reporter, but it's an emergency proceeding as anticipated under the rules. All right. Thank you all.
Judge, on behalf of everyone, thank you for your time today. I know how busy you are.
Thank you. All right. I'm gonna try and shut all of this down now. Thanks.
Thank you.